State, before we got started today, I asked you if March 12th at 11 a.m. would work as a pretrial for you. Does March 12th at 11 a.m. work?
Yes, sir, Judge, that's fine.
Defense, I asked the same of you. March 12th at 11 a.m. Does that work?
Your Honor, it does, as long as Mr. Michaels, I've got a hearing in Seminole County. If he could cover for me this hearing, it'll be fine.
Of course. Okay. Second, civility. I've been doing this long enough to know that no matter what I say in the next 5 minutes, there's going to be a lot of people that are going to be unhappy. One side or the other, both sides feel very passionate, and it's when you are initially unhappy, you're tempted to say or do something that you wouldn't normally do. It's probably not a better illustration of that than what's going on, what brings us here today. So to that end, think right now how you would feel if the decision went against you. Think right now how you would feel if the decision went for you. If the decision went for you, while you may be happy, you would know that if the decision went against the side that you want, or against that side, you would not want to see the others celebrate in your face or do anything to attempt to provoke you. And vice versa. You would want to be treated with respect, and you would want to treat others with respect. So, to that end, take a few moments before you react. And when you react, if you choose to, please react outside of the courtroom. I've watched too many of these things escalate a bad situation into a worse situation. We don't need that here. As I sit here and you wait for me to rule, I can tell you that I have been in this position before. I've felt this position before. It feels like this is a verdict, but this is not a verdict. I am not finding anybody guilty or innocent of anything today, and it's not to be interpreted as such. No matter what my ruling is on this motion, Mr. Reeves, nothing changes about the fact that you are presumed innocent of this charge. Nothing changes. I'm not endorsing your self-defense position, nor am I saying that your self-defense position is wrong by my ruling in this matter. It is a pre-trial ruling for the purposes of determining detention. It's not a finding of guilt or a finding of innocence, and it needs to be clearly understood in that way. To that end, the decision of the court, after listening to all of the evidence, after reviewing the very well prepared briefs that were provided, after reviewing the evidence and specifically listening to the tapes, after listening to the argument of counsel for both sides, the court is going to find that the state did in fact meet their standard, and I am going to detain Mr. Reeves pre-trial. He will remain in custody, remanded to the sheriff of Pasco County. Mr. Reeves, you have appellate rights on this. You can't appeal this, and the appellate courts will have a chance to review everything that I've done, and if they decide that I've made a mistake, it comes back, and I would give you a bond. And because I know it is a possibility that I will be appealed, the probability that I will be appealed, and because I know that they may send it back, I want to put on the record what I would have done if I did not find that the standard was met. So that if they send it back and say, Judge Syracuse, you are wrong, they know what I would have done. What I would have done was I would have given you a $150,000 bond, which would have been consistent with my observation of people with no prior record charged with second-degree murder. I would have, and that's from looking at the entirety of the 6th Judicial Circuit, I would have ordered that you would have remained on a monitor at your house. I would have ordered that you would have had contact only at your church and at the grocery store if you wanted to go grocery shopping. I would have ordered that not only you be dispossessed of all your firearms that you currently own and placed in the custody of the sheriff's office, but I would have ordered that no firearms would be brought into your presence by anybody that was a friend or associate of yours. In other words, if your son, who is a law enforcement officer and who is allowed to carry a firearm, if he was coming to visit you at your home, he would not be able to bring that firearm into the home. So that would have been my ruling had I not found the standard met. Having found the standard met, though, I have to detain you pre-trial, and we'll be in recess then on this case until March 12th of
Your Honor, I do have one matter that I'd like to clear up for the court. Since the videos have been presented, I think it's only fair to, at this point in time, for me to agree that the videos that were introduced into evidence be released to the media. I think it's only fair for them to be able to view it on their own software, on their own computers, so that they can see for themselves.
Let me ask the state if they have any objection. State, do you have any objection?
No, sir.
Okay, if you're agreeing, then I will allow it to be released in its raw form through the discovery request. And state, you've gotten the agreement of the victim, is that correct?
Yes, sure.
Yes, sir.
Mr. Grimaldi, you're okay with that?
Before, it's fine, Your Honor.
Okay, great. Then we'll be in recess until March.
All right.
I got an email during the week or so, 2 emails came in that I didn't have a chance to look at. Yeah, no, I did get them during the lunch. Yeah, all I know. You did a good job.
Well, thank you. I appreciate